Welcome to everyone joining us here today. What are we talking about? 2023 special needs updates. What do you need to know if you have special needs planning issues and you want to make sure that you're in a great place as we look to the future? And as we get started, I want to just review a couple of, hold on, I'm having some issues, of course. There we go. Think about why you're here. Are you concerned about your special needs child or loved one? Are you confused about 2023 laws? Are you just unsure of what to do? Do you just feel overwhelmed? And I think many of you here can probably relate to this. We hear this all the time. I'm afraid to die. And that's not a fear about your own mortality. It's about who's going to take care of my special needs loved one after I'm gone, my daughter or my son, because they need me. And they need extra assistance. Who's going to step in? How can I make sure that they're covered? And that's really what this is all about. We want to help you control what you can control. We're going to go over what you need to know about special needs planning in 2023. Our purpose here is not to go over every mundane little sub rule, but the high level rules you need to know and the steps that you need to take as you jump into special needs planning. So what are we going to cover here today? It's a lot. We're going to break it down in plain English. So these are out of order. I'm not sure why. Sorry, my animation skills are not so great in PowerPoint, but we're going to talk about just the high level. What do you need to know about special needs trust? What is a special needs trust? How is it part of your overall estate plan? And how does it need to be integrated with your estate plan? We're going to talk about some critical new property tax laws. If you listen to us in other talks, you're probably aware of this, but we're going to go over what it means if you want to save your house for your loved one or a rental property. Updated ABLE Act rules. There are some new rules that we're going to talk about. Really important for you to understand those. Updated Medi-Cal and long-term care rules, because special needs planning isn't only about your child, it's about you and making sure your assets are protected. So there's assets there for your loved one, whether it's your child, a sibling, or anybody else. Concerns, Mike talked about this, he'll talk about this more, but concerns about resources available. There are government resources available, but we're concerned about that. And in light of that, the next issue, filling the gap. What do you do if you're concerned about government resources? You want to make sure you have that financial safety net. How can you make sure if there's a gap that you can fill that? Make sure there's enough there to support your loved one. And we're going to go through some 2023 planning checklist steps you can take to make sure your plan is up to date, to make sure you and your family and your loved ones are covered. And always have to point out, this is for educational purposes only. This is not official legal advice. This is not create an attorney-client relationship. We have to meet with you one-on-one to give legal advice and for an attorney-client relationship. This is meant to empower you. And if you're watching this as a recording, or it will be posted on our Gilfix Law YouTube channel, if you're watching it there, great. Share this if there's anybody in your circle who could benefit from these points or who faces these issues. So, Mike, why don't you give us an intro of what special needs trusts actually are? Before that, just for those of you who don't know us, just about our firm. We are Gilfix and Mark Associates. We're based in Palo Alto, California, but we serve clients throughout the state of California. So if you're in California, we can work with you from San Diego all the way up to Wairika. We've been around for over 40 years. We are also very proud of our history in special needs planning. Mike helped to start one of the first free legal aid programs for Americans with disabilities. Mike, just briefly, you want to talk about your history in the special needs planning world?
Sure. Gee, I went to Stanford Law School, as many know, and when I graduated in 1973, I set up the first free legal aid program for the elderly, like people my age and younger, first in the country. And in 1976, we created something called the Disability Law Center and started focusing on these issues before people knew they were issues. So we were groundbreaking. We've been focusing on these issues ever since. It's we look at it as a privilege, frankly, to be able to deal with this particular community. Integral part of our work.
Yeah, and we've worked with thousands of families in California and certainly hundreds and hundreds of families with special needs issues. And our mission and our goal is to provide extraordinary value, peace of mind, and return on investment, and to really be your partner as you think about planning. So I think many people here can relate to this. A diagnosis changes everything. And if you face that, that's where special needs planning is so critical. So, Mike, why don't you talk about what special needs trusts are and how they work?
Sure. So fundamental to special needs planning is the special needs trust. It's not the only thing. I think a lot of folks make the mistake of thinking, oh, I did a special needs trust. Now I can relax. As we'll see as we go along today, that's part of the solution. It's not the only component of a plan. But the special needs trust is critical. The point is, any amount of money can be left to a special needs trust for a child or other family member with a disability. None of that money counts. None of it interferes with eligibility for needs-based government programs. We're not going to go through those programs, but there's an income program called SSI. There's Medi-Cal to pay a health insurance program, subsidized programs in many spheres. So again, any amount of money can be in this trust. It's a lifelong safety net. As long as your child lives, that trust can remain intact, paying for anything that the child needs that isn't covered satisfactorily by some form of government benefits. So it's a necessity. It can hold real property. Many folks want to leave a home, a safe place for your child to live. That can go into a special needs trust. It can obviously and has to hold some money because, again, the whole point is to pay for things that some government program doesn't satisfy to a reasonably high level of quality. Where it isn't just quantity; it's about quality as well. So, special needs trust, it's a necessity. It works in conjunction with your revocable trust and other elements of your plan. So, we have authored a book on this topic. Many of you have it. It's the Special Needs Trust Management and Creation Guide.
They're on the left side of the screen.
Yeah, here's a screenshot. It's available on Amazon. It's available through our office, and it does we believe a very good job. We have great reviews. It's in English. You can understand it. It's not legalese. It goes through the basic elements of what this trust is. How does it fit into the plan? What's the money used for? Pick it up if you don't already have a copy. If you have set up a trust and you haven't given a copy of the book to your chosen successor trustee, what a great gift it would be to that person. So they have a good sense of what's going to be going on. So let's talk a little bit about what the money can be used for. We get this question all the time. And by the way, in the book, there's even more detail about this, gives a little bit more context. But, it can be used for darn near anything. I mean, again, to the extent that a beneficiary of one of these trusts has needs, if they're taken care of by Medi-Cal because it's a healthcare need and the provider of the Medi-Cal services is a good quality, that's the end of it. Medi-Cal pays for it. But if there's a medical care need that is not going to be paid for by the Medi-Cal program, that's what the money in the trust can be used for. Entertainment, therapy, buying a skateboard, buying a new computer. There's some great stories we're not going to get into about, let's just say, some very creative, out of the box uses of money in the trust. There's some really remarkable stories around the country. Use your imagination here. The money can be liberally used. And that's really the bottom line. This underscores, last comment, the need for your trustee to really understand that this is to be, the money in the trust is to be liberally used. It's to enhance the quality of life of the beneficiary. So that's what this is all about. Very few restrictions, right, Mark? What's next?
Yes, you might be thinking, can special needs trust funds be used to buy Britney Spears tickets? Although there's a whole other legal saga Britney Spears has been through, you may have heard. So I don't know if she's performing now, but there is actually a court case where Britney Spears concert tickets were okay. Special needs trust funds were okay by a court to purchase Britney Spears concert tickets, just to give you an idea how flexible these funds can be and what they can do to improve your loved ones or your child's quality of life after you're gone, without interfering with government benefits. So Mike alluded to this, but it's really critical. It's not just the special needs trust. It should be a separate standalone document. It should not be integrated with your living trust. Many reasons for that. Integrated as in it shouldn't be part of your living trust. We've seen some documents where it's embedded in language in the living trust. It should be a separate document for many reasons, but it still needs, of course, to be integrated with your living trust and the rest of your plan. So you obviously need to make sure mom and dad need their own living trust. So when they pass away, unless that's stuck in the court, and they go properly to the special needs trust. You have to have the right structure there. We have whole webinars and talks on that. If you have questions about your own planning, of course, we can help you to update your plan and make sure it's all fits together. Laws change over time. I also want to make it clear your power of attorney document. That is secondary. Often it's not as central to your plan as your living trust, but that's what the document that governs who can step in to manage your day-to-day financial affairs if you're incapacitated, your business of life issues. That has to be integrated with this as well. So power of attorney documents should have special needs provisions if you have a loved one with a disability. So it should not just be a check the box off the shelf document. So just to say, if you face these issues, you need to regularly review your plan, make sure your living trust is integrated with your durable power of attorney, and that they're both integrated with the special needs trust. And we also have to make sure retirement accounts, life insurance policy, financial planning, that's all integrated as well. We're going to talk about that in just a little bit. But why don't we transition to a critical issue, and that's housing.
Yeah, nothing is of greater concern, right, than the question of where is your child going to live? For the vast majority, there's no good answer. For many in this community, there is a plan that the residence is going to be retained for your child with special needs, or there's a second property that you may own if you're so blessed, and that's the plan. Well, we have a development in California that undercuts and really threatens that objective. So we're going to talk for a moment about Proposition 19, new law as of last year. So this is brand new stuff. We integrate this topic into every webinar we're giving these days because hardly anybody knows about it. It's a time bomb. It's a time bomb that interferes with best laid plans for retaining property in your family. So let's go through the elements of it. We had Prop 13 now going back many years, right, that roll back property taxes. We had Prop 58 that allowed us to pass along our residence and other property to our kids without any property tax increases. Well, Prop 19 torpedoes Prop 58 and all of those protections and benefits. The presumption in Prop 19, by the way, Prop 19 covers many points. This is for today, it's the most important, and we think it's the most important overall. It says that there is a presumption that upon your passing, when property goes to the next generation, there's going to be a complete reassessment. We're going to have some examples in just a moment. This means the loss of a fortune in property tax money if you don't plan and think about it. Increases that we've seen of 1,000% and more in property taxes. We had a call last week from somebody, mom just died. They didn't know about this. They wanted us to fix it. Well, it's too late if mom has died and the property's already been passed along or is about to be passed along. What drove us a little crazy, we think, is just so unfortunate and unethical, basically, is that there's no exceptions built into this new law for families with special needs, where there's a particularly vibrant need to keep property available for the child who has special needs. So there's no exceptions, none whatsoever. So let's go on to the next one and look at some a few more details and get some examples so you can just really see what this means. So let's assume that you own a home around here. You bought it a long time ago. Property taxes are $3,000, $4,000, $5,000 a year, $4,000 in the example. And let's say your home is now worth $3 million. It's an ordinary home in Sunnyvale.
Which is still crazy, by the way. And that's true for Southern California, Northern California. There's so many areas where 2 to 3 million is like a normal house, which boggles my mind. But anyway,
it does, yeah. So, that's good about it, but the property tax impact can be just devastating. So let's look at what happens with the family home. Now, there is one exception, we emphasize, partial exception built into this new Proposition 19, this new law. It says that if a child becomes the resident of your residence, it's the third bullet point under the family home, the first $1 million in assessed value is forgiven. So if we have this profile where the home is worth about $3 million and the child moves in and makes it his residence, property taxes are still going to go from about $3,000 or $4,000 a year up to about $23,000 a year. That's like a $20,000 a year increase. And that's if they move in. That's the exception. That's the protection. If they don't move in and make it their residence, which is more likely in the vast majority, there's a complete reassessment, no exceptions. Non-resident, the property taxes would go to about $34,000 a year, a $30,000 increase in a single year. And of course, this goes on year after year after year. If it's not the family home and it's a rental property or it's a cabin in the mountains, whatever the property taxes are, again, in our hypothetical here, they're $3,500 a year. You bought it a long time ago. The nice place at Tahoe, you should be so lucky. Now it's worth...
Or rental property. That could
or rental property, either
after
one.
You're gone, yeah.
Market value about $2.8 million. No exceptions, no matter who lives in it. Property taxes would go to about $30,000 a year. Now, if there's a ton of money sitting in the special needs trust, if that's where it's going, maybe there's enough money to service that tax bill annually. But the problem is, in so many cases, this tax bill is going to make it impossible to retain ownership of the property. It's devastating. So if you don't fix it, if we don't take steps to address this and capture and retain the current level of property taxes, you're looking at the for sale of the property after you're gone, because the kids won't, or the trustee of the trust won't have any real alternatives. It's a devastating development in the law that we think is so unfair, but here it is. We do have solutions. We do have solutions. That's the most important point to emphasize right now. We're taking care of this for about 20 to 25 clients right now. It's not a simple process, but it can be done. Lots of tax issues that we have to think about and integrate.
Yeah.
Millions of dollars in some cases are at stake, literally millions. So we do have solutions. If you're concerned about this, and I think any homeowner should be concerned about it. If you're in your 50s or 60s and you have a parent who owns property around here, you're the one who's going to inherit it, right? So you're thinking about property you own, the impact on your kids. You're thinking about property your parents own and the impact on you. So in either of those situations, perhaps more imminently with regard to property, a parent, and let's face it, I mean, the older we are, the more likely we're going to pass and there'll be a transition of ownership, bringing on this property tax increase. So heads up, don't ignore it. We do have another webinar on this. We have our YouTube channel, but you don't need to go to the webinar. You can, of course, but if you want to address this, don't wait. Don't wait.
Yeah. Talk to us, basically. That's it. If you have this concern, and something facing everybody who has property in California. Let's talk about a spear update in law, which relates to CalABLE, the ABLE Act. So you may be familiar with this. The ABLE Act at a high level is a program that was started just a few years ago. It was a federal law that passed that allows, this is something that goes alongside a special needs trust. It doesn't replace one. But if there's a smaller amount of money that you want to put into a special account for your child or your loved one with special needs, the ABLE Act allows you to put up to $100,000 into a special account. It has some tax benefits. Assets can grow without facing some taxes, kind of like a 529 plan. And as long as there's under $100,000 in an ABLE Act account, the money in it can be there for your loved one with special needs. They can even manage it, and it doesn't interfere with government benefits eligibility. So it's a way to put smaller amounts of money away for your loved one, kind of separate from a special needs trust. Unlike a special needs trust, they can be in charge of this account, by the way. They can write checks or use money from it. Special needs trust, they can't. So it's kind of a nice tool alongside a special needs trust. There are some limits, though. You can only put up to $17,000 per year into an ABLE Act account. That's the annual gift exemption under the IRS. That went from $16,000 last year to $17,000 this year. That's the amount you can give to anybody without even reporting to the IRS. That's what the ABLE Act allows per year. And so it's not like $17,000 per person. It's $17,000 total can go into an ABLE Act account. But one of the downsides of an ABLE Act account, well, one, if it gets over $100,000 in the account, if it keeps growing and you get over $100,000, you can have trouble with government benefits eligibility. So you want to keep it under $100,000. But one of the downsides previously was any money left in an ABLE Act account was exposed to a clawback from the state of California. So if your child had an ABLE Act account and there was $80,000 in it when they passed away, if they got $80,000 in certain benefits from the state of California, the state had the right to go after that money. So it wouldn't go to other family members. The state of California would get it all back. Well, there's a change in law. So now if you set up an ABLE Act account in California, there will not be a clawback or a reimbursement claim for Medi-Cal. So if the child receives Medi-Cal benefits during their life, which is one of the key programs, if it's a California-based ABLE Act account, the money will not be taken by the state of California. So this just says, hey, in the early days, we used to advise people, hey, set it up in any state, because some states were ahead of California in rolling these out. I know Ohio was way ahead of California, but now you want the ABLE Act account to be in California to avoid this clawback. In other states, I believe the clawback is still there. And Mike, wasn't there was a change in the ages at which you had to be diagnosed as having a disability to be eligible, which was an absurd rule, but they changed it.
Yeah, it really expands the availability of the program. As originally conceived and as applied in California, you had to have been diagnosed with a disability before age 26. The change in law says that now you might have been diagnosed as late as age 46. So again, it opens up this program to more and more individuals. We have a summary of the benefits of the program in our special needs book, by the way.
Absolutely. Let's now talk about Medi-Cal rules. And our focus is really on long-term benefits. We'll talk about why that's so critical. But Mike, why don't you lead us through some of the new Medi-Cal eligibility rules?
Sure. And again, Medi-Cal is California's version of the federal Medicaid program. So it's a program that's available to individuals who are disabled and who qualify, and we'll go through the qualification eligibility criteria here in just a moment. One of the most important benefits under Medi-Cal is it's the only program that can pay nursing home bills. Now, again, our focus in special needs is usually on a kid, but many folks set up special needs trusts for their parents because they want to make sure that their parents have a cash reserve if the kid should, God forbid, die before the parent, and the parent's receiving Medi-Cal benefits while in a nursing home. So it is a program that's core to long-term care planning. Everybody needs to know about it. In a moment, we'll make reference to the book that we've authored on this topic. But there's big changes in the eligibility criteria. It has been the case until now that for an individual in a nursing home to qualify for Medi-Cal coverage, she couldn't have more than $2,000 in her name in countable assets. Many assets don't count, but cash couldn't have more than $2,000. The dramatic change is that as of July 2022, an individual can have up to $130,000 and still qualify. Only in California. We hear that a lot, don't we? I mean, all kinds of things. Only in California. In addition to that, the spouse at home, if you're married, the spouse at home can have a minimum of almost $150,000. You put those together, I mean, that's a whole lot of money that can be preserved, $275,000, $280,000. The home is exempt. Money in retirement accounts are exempt. So the program is available with good planning. Assets can be protected. Many protections built in. Now, we believe that this has implications going forward. It's expanding eligibility. So let's go to the next slide and we'll talk about that. So we have something to guide us here. Here's the reference to our book, Facing the Reality of Long-Term Care. But for the reference to $130,000 for eligibility, it's up to date. So everything does have to be integrated as we look at these issues. There's so many tax issues we have to think about. Again, as we said, so don't do it at home. You do need to talk with us so you don't make mistakes about capital gains tax, gift tax, estate tax, property tax, on and on. So again, all of these things have to be integrated for a family multi-generational plan where we're taking all of these things into consideration. Now, what are we concerned about? What's the good news? What's the good news and what's the bad news? Well, the good news, I guess, is that eligibility criteria have been softening. Now 130,000 in 2024 or perhaps a bit later. Even that cap is going to be eliminated. Everybody in a nursing home is going to be eligible for Medi-Cal. Good news, right? Everybody gets it. Everything has a cost, right? Everything has a downside. So as we're looking at individuals who need coverage and care, we're of course delighted about every expansion, but the money has to come from somewhere. Something has to give. Is it going to be increased taxes on all of us? Probably. What are the other potential impacts? Now, if a skilled nursing facility accepts Medi-Cal, if they're called Medi-Cal certified, that means they accept the Medi-Cal rate as payment for the monthly cost of care of a resident. That's quite a bit less than the private pay rate. We're concerned that a number of facilities that now accept Medi-Cal will no longer accept Medi-Cal. The cost of running a facility, to be fair, is going up. The reimbursement rates never keep up. Supply and demand says that there's going to be more demand for private pay where there's at least the perception, if not the reality, of higher quality care. We're just worried that there's not going to be enough quality care out there. So it leads to a conclusion that we haven't always drawn, although in the recent past we have, which is increasing importance of long-term care insurance. We didn't always have this view, but if you're going to pay for home care, which is getting to be $30, $35 an hour, it can be $100,000, $200,000 a year. Well, long-term care insurance can help. And long-term care insurance, by the way, there is an objective need for many people to have the money there to pay. And I've sure learned that there's a subjective reason for having long-term care insurance. You sleep better at night, even if theoretically you can afford the cost of care. It just makes you feel a little bit better that you've got this cushion built in. So long-term care, we think, is to be considered much more dynamically than in the past. There's going to be more changes. We're going to be tracking them carefully. Again, Here's our book. We track issues like this. We talk about them on our Gilfix Law YouTube web channel. So you really should sign. I mean, if you're interested in these things, we work very hard to stay up to date and to keep our talks kind of light, even though there's a lot of content. So sign up, go to that page, and you'll find all kinds of content. So
Yeah,
eligibility is key.
Yeah, and this all relates both for your child, but also for you. If you can't protect your own assets, how's there going to be anything there for your loved one? So that's really how this all ties together so critically.
And by the way, let's not forget, if you have any questions, we forgot to mention, enter them in the Q&A function. Just write in your question. We'll take a look, and time allowing, we'll be happy to respond. So go for it.
So now let's talk about, we've talked about what we can do to the changing rules around protecting your assets if you need long-term care, because 70% of us, as we reach the age of 65 or older, are going to need some type of long-term care. This also applies to your child if they need long-term care down the road. But there's a lot more to supporting somebody than just this. So let's talk about the resources needed and some of the numbers we've seen to support someone through their lifetime in a special needs trust.
Yeah. So here we go again, being objective and looking at what things are really going to cost and what does it really mean in real life when you have to put together a special needs plan. Again, emphasizing, underscoring long-term care, day-to-day care for somebody who has special needs is so complicated. You have to think about it from many different perspectives: financial, insurance, obviously legal planning, government benefits. So our job is to integrate all of that for you. The numbers on the lifetime cost of care for somebody on the spectrum, you see numbers all over the map. Let's face it, it depends on the level of functioning. Some individuals are high functioning on the spectrum, and some have no functioning on the spectrum, not to mention many other types of disability.
Exactly.
1.4 to 2.5 million and more. Most don't have that kind of money to set aside. So, we're very sensitive to this fact. But what is the real cost? Well, here it is. And when we talk about the cost, money is only one cost. Family stress. What does it do to the family? The divorce rate, where there's a couple with a special needs kids, is dramatically higher than the divorce rate for others. And isn't that logical? Stress. Who's going to absorb all of the hassles that you have to encounter and deal with on a daily basis? It's consuming. So we're very aware of all of that. And again, that's why we try to so comprehensively look at this. Again, concern, the cost of care. Here we go with some numbers. The number of individuals with disabilities is increasing dramatically. We see this every day. First of all, disabled seniors. In 2015, the data are about 1 million in California disabled seniors receiving Medi-Cal, other kinds of support. In 2060, not that far away, 2.7 million, almost a threefold increase. The cost of care currently over $100 billion for this segment of the population. It absorbs about 40% of all of the healthcare costs, expenditures here in the state of California. Resources are not increasing. Not only is the money not increasing, the supply of caregivers is shrinking. Immigration restrictions, less attractive work, rates of pay. So again, all of these pressures mean that we have to be resourceful and creative as we proceed. We've mentioned housing, how that is such a key. Being sure, if you can, that your child will have a safe place to live. And remember that harkens right back to that property tax problem that we have, where if you want to set aside your home or another property you might have for your child, you have to think about it now. Don't just say it in your trust and let it be because of the time bomb with Proposition 19. So again, the cost is going to go up. The resources are shrinking. It underscores the need for a special needs trust and integrating all of these types of planning. So as we think about how much is enough and what are you going to do, again, very few people can set aside like a property, let alone $2.5 million. So one of the things that we emphasize is, Mark, did you want to say something?
Yeah, no. So how do you fund? How do you ensure there's a safety net there? And there's a couple ways to think about this. And I want to just take a moment to think about, how do you calculate how much you're going to need, by the way? Because you know how many assets you have. You hope it's going to grow over time. Hopefully we can protect your assets even if you need long-term care by being aware of Medi-Cal rules. But a lot of people ask, well, I don't know how to think about how much should be there for my child. So how do you, what's a way that we can kind of calculate this? So one way I like to advise families is to think about this sort of like retirement planning. So the general rule of thumb historically was, if you plan on retiring, how much do you need there to support yourself? Well, the general rule historically was you could take about 4% of principal out every year, and your principal should last forever. Maybe that's a lower percentage now with inflation, I don't know, but let's say it's 3 to 4%. So in plain English, let's say you have $1 million put away and invested, and that's your nest egg. The general rule of thumb was you could take 3 to 4% of that, $30,000 or $40,000 per year. And as long as it's invested in an intelligent and conservative way, that $30,000 or $40,000, you should be able to take that every year, and you should never have to invade the principal. It should stay at about $1 million for the rest of your life. Maybe we have to adjust those assumptions a little bit. Very simply, think about support for your child in a similar way. Calculate what they need in current monthly support costs now and what those might be in the future. So let's say your child needs $10,000 a month for support beyond what government benefits are going to give. So, okay, let's use this rule, a 3 or 4% rule. They need $10,000 a month. That means they need $120,000 a year from that special needs trust. Okay, how much needs to be in the special needs trust? So a 3 or 4% return every year gets you to $120,000. So we always talk in more depth than that, but I think a very simple, and it's in our book as well, the Special Needs Trust Creation and Management Guide, where we go into this in more detail. But really important, we're going to talk about the importance of an integrated plan, but this is a way to think about it. And you might go through this calculation and say, oh gosh, I don't have enough. And maybe a big chunk of your estate, is in your house, right? So you might have a larger estate, but if a huge chunk of that's in your house and you want your child to be there, well, the house isn't going to really generate income if they're living in it. So you got to think about filling that gap with other assets. So a very powerful tool for this is life insurance. So Mike, why don't you talk just briefly about how powerful that can be and how it can work?
Let's go to the example, because this example, it just tells the tale so profoundly. This was a couple who came to see me a few years ago. They had 2 kids. One was profoundly disabled, about 2 years old. It took an hour and a half to give that child a meal because they had to use an eyedropper kind of thing, just dropping little bit by bit to give that kid enough nutrition to live. And it was consuming. It's all they could do. They had another kid who was perfectly healthy. In fact, he was in the meeting running around the room. I will never forget it. Just vibrant, great kid. And this couple, they were in their 40s, didn't have a lot of money. And they believed that they were going to have to leave every penny they had for the benefit of their special needs child because he was so profoundly disabled. And when they first mentioned that, the wife just started crying because that meant, and she said, that means we can't leave anything for Johnny, for the other kid. And you can imagine how disturbing. Now, very relevant was the fact that the wife's parents accompanied them to that meeting. They wanted to be supportive to see what was going on. At some point, because they didn't have a lot of money at all, they were still, I wouldn't say struggling, but not doing that well. I raised the possibility of a life insurance plan. And long story short, as we got a professional involved, they were young. They were looking at what is called a second to die policy, which makes the premiums a little bit cheaper. And the question was, what would it cost to purchase a $1 million life insurance policy? And the policy would name the special needs trust as a beneficiary. So the family would know that no matter what, there was going to be $1 million in that special needs trust. So the 2 options that became most attractive, one said lifetime, every year they'd pay about $4,200. The other option was a single payment, one only for $60,000, which they couldn't afford. But remember, the wife's mom and dad were there. They said they would help out. They kicked in about half of that single premium. They bought the policy. They named the special needs trust as the beneficiary. And the wonderful thing about that, and I'll tell you, it was incredibly emotional. After all this happened, the wife called me up and she told me that for the first time since that child was born, because of the policy, because they could stop worrying about something so huge, they, for the first time, felt they could take a night off and go to Monterey, and the grandparents babysat with that child. It was absolutely liberating. They changed their plan, left a portion of the estate for their well child, their able child. It changed their lives. So, that's a profound situation where it just was a change of life for them. But again, life insurance is a way of locking in a benefit, and it just has to be considered in a special needs situation. Every advisor around the country agrees with this advice. It's so objectively accurate. So you got to be thinking about that.
Yeah, this is an example. These numbers were just illustrative. It can vary based on your age and your health and everything like that. But it's extraordinary what you can get for one payment. That's what blew me away when I first learned about this. And so I had a meeting this morning where we talked about this to fill the gap. Let's talk about retirement accounts. So Mike, why don't you lead us through
Sure. So
benefits of leading retirement accounts?
if you do have a retirement account, IRA, 401k, 403b, whatever it may be, you have to designate beneficiaries. You do not want to name a special needs child as the beneficiary because the receipt of that income could eliminate SSI, supplemental security income eligibility. It could even jeopardize Medi-Cal eligibility, not to mention the management issue. Who's going to manage the money if it goes to that child? So one of the solutions is to identify the special needs trust as the beneficiary. Now, there's going to be at some point required minimum distributions that will come up sooner or later for the child. It comes up for you as well, right? So there are benefits in leaving it to the trust. Because of a change in law, this thing called the Secure Act, in an inherited IRA, the money has to come out within 10 years. Well, one of the exceptions to that, to use the lifetime of the beneficiary to let the money last, is if you have a child with a disability. So again, there's an exception and a protection built into the retirement account legislation, thanks to the Secure Act, that gives us a break here. And we want to take advantage of it if an IRA is going to be a major source of funding for the benefit of a child or other family member with a disability. So heads up, integrate that into the thinking. Again, it goes along with insurance, assets you have in your revocable trust. It all has to fit together.
And that leads us to just how we like to think about this with our clients and how I recommend anybody think about this. And it's really important to have an integrated legal and financial planning team. You should work with planners who can help you integrate the legal side. We're involved in that. The financial side, which include insurance, retirement accounts, and just general financial planning. We work with we have many clients who bring their financial advisors to meetings. And you also, Mike mentioned long-term care insurance. There are hybrid life and long-term care insurance policies. So if you need expensive long-term care that's not covered by Medi-Cal, which we can also help protect your assets for, the insurance policy can pay for that. And if you don't use it, hey, there can be a death benefit that can go to the special needs trust. The key, though, is you should look at this in an integrated way. There's a lot of moving parts, but when you have the right team, it can be put together very efficiently and very effectively. And we have we're building a network with a couple select financial advisors with whom we work very closely. And we're working to partner up to help some clients in a way where we all work together, we're all on the same page, and we integrate all of this planning. We make sure every year that assets are properly titled, that beneficiaries are properly designated, that gaps are properly filled, that the allocation of bonds versus equities is proper, given the special needs issues that your family faces. So make sure your financial advisor, if you have one, thinks about this in a holistic way or bring this up with them. If you don't have an advisor, if you're looking for a review of your plan and all that, talk to us. We are forming some partnerships and we offer free reviews of financial plans with some selected partners as well. Regardless, make sure that whoever you work with in these areas, that one hand talks to the other. We make sure whenever someone wants us to, that we meet with financial advisors and ideally work directly with them. And again, we're building some amazing win-win partnerships with some advisors who really think about this proactively. So talk to us if you have questions about this. I want to now go to wrap this kind of up and go through a 2023 special needs planning checklist. What do you need to think about? What do you need to know? And we will take a couple questions at the end. So feel free to enter some questions in the Q&A function if you're watching this live. 2023. So the first question is, do you have a comprehensive estate plan in place for yourself? If you don't have this is 3 key documents for you: Revocable Living Trust, Durable Power of Attorney for Finances, Advanced Healthcare Directives. You need this. If you don't have it, or if it's been a long time, you need to update this. But if you don't have it, let's help you put it into place. And of course, protective trust for your children. If you have a child with special needs, it needs to be a special needs trust, of course. Critical, the most important thing. But a special needs trust is only as good as the weakest link of the rest of your plan. So we need to make sure everything else is integrated. If you have other children, by the way, there are other protective trusts we can create for children who don't have disabilities. Family protection trusts can protect inherited assets from divorce and lawsuits and future estate taxes. So it's not just the special needs trust for your child. There are other trusts we can create for other children as well. They can protect them in different ways. And if you have an estate plan in place, when was the last time you looked at it? Do you have the right living trust structure? There are alternate structures that can have big tax implications. There can be hundreds of thousands of dollars at stake, even if you're not high net worth. We can help with that. You got to take a fresh look at that. Do you have the right successor trustees? Did you set up family protection trust for other kids? Do you have a special needs trust for your child with a disability? Or how long has it been since you reviewed that? We can update those as well. If you have a larger estate, if you're single and have over $5 million in assets, including your house, or if you're a couple and you're approaching 10 or 11 million, including your house, including life insurance, including retirement accounts, a big number, I know, but you need to then be aware of estate tax issues. Right now, you're okay. Currently, you can pass $12.92 million per person, but that number is about to drop in the beginning of 2026, barring a huge change in law. Before then, we're going to lose a lot of estate tax protections, right? As the size of your estate's probably going to be growing, hopefully, if the economy recovers, you could face major estate tax issues. So we have to be aware of this. And of course, if you own California real estate, your home, if you have a rental property that you hope can be there to support your child with special needs after you're gone, we have to be aware of Prop 19. That alone can be worth hundreds of thousands or even millions of dollars over time if you're fortunate enough to own real estate that you've had for a long time. So talk to us about any of these. Have you reviewed your financial plan and your life insurance plan to make sure they all fit together? We can help you with all these things. We can help you think it through. We can help you build that team. And I want to just talk about the 3Ds. I want to help you overcome the danger of delay and denial. We hear this all the time. My kids will never divorce. Oh, my kid will be fine. I'll get to this later. I'll live forever. I can't tell you how many meetings I've had where people say, if I die. I hate to say it, we're all gonna kick the bucket at some point. And if anybody finds the secret to immortality, please let me know. I know some billionaires like Larry Ellison, and I'm sure some of the Google guys are working on this. I don't even know if I want immortality. That would be very fraught. But we are all almost certainly going to pass away at some point. We have to think about these issues. Or you might think, well, I did these documents a while ago. I'm fine. I don't need to do this. You need to update these documents every few years, or at least address them and take a fresh look. Or you might say, I'm watching this webinar, that's great, but I don't like dealing with lawyers. If you don't deal with lawyers now and invest a bit, your family is going to be dealing with a lot of lawyers later and courts and much higher expenses and fees. So it's such an extraordinary investment to get this into place. So if you haven't yet subscribed to our Gilfix Law YouTube channel, we're now starting to regularly post more free educational content. We want you to be armed with information. If you got a lot out of this, like this. If you're watching on YouTube, like it, comment, share this with people who could benefit from it. Our book is available to all our clients. If you're a client and you want a copy of our book, Special Needs Trust Creation Management Guide, talk to us. It's available on Amazon as well. Just search Gilfix Special Needs Trust. Don't miss this opportunity to protect your assets and retain control over your life and your purpose. And let's help solve that issue of I'm afraid to die. This can be that solution to help fill a big part of that gap, to make sure that when you step out, that extraordinary and powerful, sophisticated plan is there to support your loved one. And it doesn't have to be overly complicated. We can help you break it down to just a few key steps. So it's our job to take all this stuff that we talked about and help boil it down, or just make sure if you're not working with us, we hope we get the chance to work with you, that you work with someone who focuses heavily and exclusively on special needs planning. Don't work with a generalist on this who sort of dabbles in estate planning, dabbles in this. We have worked with so many families, so we think about all these issues, and it needs to all be integrated. So if you have one gap in your plan, it can undo everything. So of course, if you're not already a client, we invite you to join our community, or at least to reach out to us, to talk to us to see if we're a fit. We can review your existing plan. We can help you build solutions or update your plan. You can easily find us at 650-493-8070 or gilfix.com. Very easy to find us. Gilfix.com, Google us. We're all over the place. But we'd, of course, welcome the opportunity to get to know you and to serve you. So please take action. Whatever you do, please take action. Share this. Let people know about Special Needs Trust. For every family like you that's watching this that knows about this, there's probably 3 or 4 that need it who are completely unaware of it. So we want to solve that ignorance problem, and we want to help you out. So why don't we then go to some questions? We have a few. So Mike, do you want to go to a couple of questions?
I do. We get this one all the time because of where we're located and our Stanford legacy. Do we accept the Stanford legal plan benefit? We don't. The attorney has to accept restricted rates. We don't need to. I hate to say, I mean, the better the attorney, the less likely they're going to accept these plans, because we're busy anyway. So no, we don't. Same person, I
Unfortunately.
believe, asked a really good question, and
Yes.
it suggests maybe a misunderstanding. Okay, the question is, can I delay setting up a special needs trust until after I pass? There's worry about this child who's on the spectrum. He's using drugs and so on and so forth, and I don't want to finance his habit after my death. Can the trustee, my trust set it up later? Well, you could say in your trust that the trustee can take that step, but you really need to set it up right now. The key point is you don't fund it now. There's not going to be money in the trust now. You create the entity as an empty shell. It sits there empty until you pass. Then the money is going to go into it. Is going to go into it. You should define all of the terms of that trust, not your
Yeah.
trustee. You know what's going on. You know the circumstances. So you don't want to wait. You really need to take
Yeah.
care of this now. With
And just to
respect,
that,
you need to do that.
yeah, to that point about substance abuse, it is a special needs trust will not finance someone's substance abuse issue. Quite the contrary. It's there, you are naming a trustee who's not your child to oversee it for them. So if they see that someone has a serious substance abuse issue, they can use money for treatment, they can use money to get help. They absolutely would not use the money to help finance the habit or just give them cash. So this creates a protective structure to make sure that money is not used for the wrong reasons. So really, when in doubt, create special needs trusts. We have another question from Barbara. Is 80 years old too old to even consider long-term care insurance? Yeah, and realistically, long-term care insurance, if you really have to be probably, I don't know, Mike, under the age of 65 or 60 for it to really make
No,
financial
I mean,
sense.
you can be in your early 70s, but the problem, the
No.
older we are, the more expensive it is, and
Yeah.
there's a greater likelihood we'd be denied. But mostly the cost becomes, you want to put together a plan where you look at your finances and you look at Medi-Cal planning as an option. Make sure all your documents allow us to do that when and if it's necessary. So, Barbara, we could, follow up on that sometime. But
Yeah.
the pieces of the puzzle can be put into place.
Yeah, we had a question about CalABLE and seeing that slide. For CalABLE, we're not going to go back to the slide, but the key thing just to remember, you can put up to $17,000 a year into it. It can hold up to $100,000. And if it's set up, it should be set up in California. We have some clients who set them up in other states. Just make sure if you want to explore CalABLE, it's that Mike, any dad, Mike, same thing. Any thoughts about that?
Well, yeah, I mean, Lydia asked if she could see this. You can go to our YouTube channel. This webinar will be posted. So we'll
Yeah.
and in a prior webinar on special need trust, we had it with a little more detail as well. So we're not going to go back right now. We can't really. We don't have time. We're not set up to do that. So sorry.
Yeah, and we have another question. If I don't own a property yet, does it make sense to create the special needs trust now, or should we wait till we buy a home? Set it up now. Set it up ahead of time. The great thing about a special needs trust and an integrated plan that's done right, you set it up once. You should revisit it every few years. But even if you don't, if you later buy a house, you later accrue more assets, you're set. If God forbid you get hit by a bus or something happens, no matter when that happens, that special needs trust is there to protect your child. So I really want to emphasize that. Don't wait to set this up. Don't wait till you have more assets. Set it up now. We can always update your plan later, but set it up before you think you need it. Plan for success. Don't plan for failure. You don't need to wait.
And another reason to set it up now is that you may have other family members, a parent, a grandparent, an aunt,
Yeah.
an uncle who may want to leave assets for your child.
Yeah.
And if the special needs trust is in existence, they name that trust as the beneficiary. Otherwise, they would name your child, which again creates a mess. So that's another reason why you always want to get it set up now.
Right. And that goes back to the integrated planning need. You need to make sure your retirement accounts name the trust, special needs trust, as a beneficiary. If you get a life insurance policy, you should name the special needs trust as a beneficiary rather than your child. As Mike said, if you have parents or aunts and uncles who might want to support, leave money for the benefit of your child, you need to have the special needs trust in place now so they can name it. If it doesn't exist yet, they can't leave it to a special needs trust, and we face lots of issues later.
So last question. It's from Susan. 2 kids with special needs. Can I gift them the $17,000 per year, or is the $17,000 a maximum that you can leave the kids together? You're kind of mixing apples and oranges there. The $17,000, that's the annual exclusion, but perhaps surprisingly, you can't. If you give $17,000 away, you don't have to report it to the IRS. Technically, if you give more than that per year, still no tax to pay, but you have to report it to the IRS. A gift to a special needs trust does not qualify for that thing called the annual exclusion. There's technical reasons why that's the case. So As a practical matter, you could put any amount of money into the special needs trust right now if you want to, and you may have to report it, but you wouldn't have to pay any tax. So don't worry about that 17,000. It's a different, it comes up in a different context.
An ABLE Act account, by the way, would be the right tool for that if you wanted to put money for their benefit. That has a limit of 17,000 per year.
Yeah.
And yeah, the maximum, I'll just address that quickly before we wrap things up. The maximum you can leave to your kids altogether, you can leave your kids any amount of money. Just know that only the first 12.92 million under current law per person is protected from estate taxes. So if you're single and you left 20 million to your kids, you have 20 million. Well, the first 12.92 million would go to them without any estate taxes. The remaining about 7 million would be subject to a 40% tax. There's no limit on what you can leave to your kids, but there are estate tax issues we have to be aware of. And that number is going to drop in coming years. So again, talk to advisors, build that integrated team. We can be a part of it to make sure that you're thinking about that. So I think on that note, and thank you, Susan. Good questions from everybody. Yeah. Thank you so much for being here. So again, if you're watching this as a recording, like, comment, share this, subscribe to our Gilfix Law YouTube channel. For those of you watching live, if you haven't, so search Gilfix Law on YouTube and you'll find our channel very easily, and subscribe. We're doing more and more videos, and we're going to put out a lot more content in coming months, all free, all meant to empower you. So I hope everybody's staying, as my mom likes to say, safe, sane, and healthy. And we hope to see you again. We have webinars almost every week, so stay tuned, and we'll talk to you soon. See you later.
Bye-bye.